In this video we are going to learn about the Indian Contract Act 1872. Introduction. The law of contract constitutes the most important branch of mercantile or commercial law. It affects everybody, more so, trade, commerce and industry. It may be said that the contract is the foundation of the civilized world. The law relating to contract is governed by the Indian Contract Act, 1872. It came into force on September 1, 1872. The preamble to the Act says that it is an act to define and amend certain parts of the law relating to contract. It extends to the whole of India. The Act mostly deals with the general principles and rules governing contracts. The Act is divisible into two parts. The first part, Section 175, deals with the general principles of the law of contract, and therefore applies to all contracts irrespective of their nature. The second part, Sections 124 to 238, deals with certain special kinds of contracts, e.g., indemnity and guarantee, bailment, pledge, and agency. As a result of increasing complexities of business environment, innumerable contracts are entered into by the parties in the usual course of carrying on their business. Contract is the most usual method of defining the rights and duties in a business transaction. This branch of law is different from other branches of law in a very important aspect. It does not prescribe so many rights and duties, which the law will protect or enforce. Instead, it contains a number of limiting principles, subject to which the parties may create rights and duties for themselves. The Indian Contract Act, 1872 codifies the legal principles that govern contracts. The Act basically identifies the ingredients of a legally enforceable valid contract in addition to dealing with certain special type of contractual relationships like indemnity, guarantee, bailment, pledge, quasi-contracts, contingent contracts, etc. It basically defines the circumstances in which promises made by the parties to a contract shall be legally binding on them. This unit refers to the essentials of a legally enforceable agreement or contract. It sets out rules for the offer and acceptance and revocation thereof. It states the circumstances when an agreement is voidable or enforceable by one party only, and when the agreements are void, i.e., not enforceable at all. What is a contract? The term contract is defined under Section 2(h) of the Indian Contract Act, 1872 as an agreement enforceable by law. The contract consists of two essential elements: an agreement, and its enforceability by law. Agreement meaning. The term agreement given in Section 2(e) of the Act is defined as every promise and every set of promises, forming the consideration for each other. To have an insight into the definition of agreement, we need to understand promise. Next is enforceability by law. An agreement to become a contract must give rise to a legal obligation, which means a duly enforceable by law. Thus, from above definitions it can be concluded that contract is equal to accepted proposal, agreement, and enforceability by law. Next topic is promise, acceptance. Section 2(b) defines promise as when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. Proposal, when accepted, becomes a promise. The following points emerge from the above definition. First, when the person to whom the proposal is made, secondly, signifies his assent on that proposal which is made to him. Third, the proposal becomes accepted. Fourth, accepted proposal becomes promise. Thus we say that an agreement is the result of the proposal made by one party to the other party, and that other party gives his acceptance thereto, of course for mutual consideration. On elaborating the above two concepts, it is obvious that contract comprises of an agreement, which is a promise or a set of reciprocal promises, that a promise is the acceptance of a proposal giving rise to a binding contract. Further, Section 2, H, requires an agreement capable of being enforceable by law before it is called contract. Where parties have made a binding contract, they created rights and obligations between themselves. Next topic is rights and obligations. Obligation is the legal duty to do or abstain from doing. Where parties have made a binding contract, they have created rights and obligations between themselves. The contractual rights and obligations are correlative, that is, go together.
Next topic is essentials, elements of a valid contract. Intention to create legal relationship. Next, lawful consideration. Next, capacity of parties. Next, legal formalities. Next, not declared to be void. Next, possibility of performance. Next, certainty of meaning. Next, lawful object. Next, free consent. Next, offer and acceptance. In terms of Section 10 of the Act, all agreements are contracts if they are made by the free consent of the parties competent to contract, for a lawful consideration and with a lawful object, and are not expressly declared to be void. Since Section 10 is not complete and exhaustive, so there are certain other sections which also contains requirements for an agreement to be enforceable. Thus, in order to create a valid contract, the following elements should be present. 2 parties. 1 cannot contract with himself. A contract involves at least 2 parties, one party making the offer and the other party accepting it. A contract may be made by natural persons and by other persons having legal existence, e.g. companies, universities, etc. It is necessary to remember that identity of the parties be ascertainable. For example, to constitute a contract of sale, there must be 2 parties, seller and buyer. The seller and buyer must be 2 different persons, because a person cannot buy his own goods. Case study. In State of Gujarat vs. Ramanlal S. & Co., when on dissolution of a partnership, the assets of the firm were divided among the partners, the sales tax officer wanted to tax this transaction. It was held that it was not a sale. The partners, being joint owner of those assets, cannot be both buyer and seller. Next is, parties must intend to create legal obligations. There must be an intention on the part of the parties to create legal relationship between them. Social or domestic type of agreements are not enforceable in court of law, and hence they do not result into contracts. For example, A sold goods to B on a condition that he must pay for the amount of goods within 30 days. Here A intended to create legal relationship with B. Hence the same is contract. On failure by B for making a payment on due date, A can sue him in the court of law. A husband agreed to pay to his wife certain amount as maintenance every month while he was abroad. Husband failed to pay the promised amount. Wife sued him for the recovery of the amount. Here, in this case, wife could not recover as it was a social agreement and the parties did not intend to create any legal relations. Case study: Balfour vs. Balfour. Next is other formalities to be complied with in certain cases. A contract may be written or spoken. As to legal effects, there is no difference between a written contract and contract made by word of mouth. But in the interest of the parties, the contract must be written. In case of certain contracts, some other formalities have to be complied with to make an agreement legally enforceable. For example, contract of insurance is not valid except as a written contract. Further, in case of certain contracts, registration of contract under the laws which is in force at the time is essential for it to be valid. Example, in the case of immovable property. Thus, where there is any statutory requirement that any contract is to be made in writing or in the presence of witness, or any law relating to the registration of documents must be complied with. Certainty of meaning. The agreement must be certain and not vague or indefinite. Example, A agrees to sell to B 100 tons of oil. There is nothing certain in order to show what kind of oil was intended for. Example, XYZ Limited agreed to lease the land to Mr. A for indefinite years. The contract is not valid, as the period of lease is not mentioned. According to Section 10 of the Indian Contract Act, the following are the essential elements of a valid contract. First, offer and acceptance or an agreement. An agreement is the first essential element of a valid contract. According to Section 2(e) of the Indian Contract Act, every promise and every set of promises forming consideration for each other is an agreement, and according to Section 2(b), a proposal when accepted becomes a promise. An agreement is an outcome of offer and acceptance. Next point. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. This can also be understood as identity of minds in understanding the terms vis consensus ad idem. Further, such a consent must be free. Consent would be considered as free consent if it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. For example, A, who owns 2 cars, is selling red car to B. B thinks he is purchasing the black car. There is no consensus ad idem and hence no contract. To determine consensus ad idem, the language of the contract should be clearly drafted. Thus, if A says, B, will you buy my red car for 30,000 rupees? And B says yes to it, there is said to be consensus ad idem, i.e. the meaning is taken in same sense by both the parties. For example, A threatened to shoot B if he, B, does not lend him 2,000 and B agreed to it. Here the agreement is entered into under coercion and hence not a valid contract. Students may note that the terms coercion, undue influence, fraud, misrepresentation, mistake are explained in the coming units. Next point. Capacity to contract means the legal ability of a person to enter into a valid contract. Section 11 of the Indian Contract Act specifies that every person is competent to contract who, point 1, is of the age of majority according to the law to which he is subject, and point 2, is of sound mind, and point 3, is not otherwise disqualified from contracting by any law to which he is subject. A person competent to contract must fulfill all the above 3 qualifications. Qualification, in point 1, refers to the age of the contracting person, i.e. the person entering into contract must be of 18 years of age. Persons below 18 years of age are considered minor, therefore, incompetent to contract. Qualification, in point 2, requires a person to be of sound mind, i.e. he should be in his senses, so that he understands the implications of the contract at the time of entering into a contract. A lunatic, an idiot, a drunken person or under the influence of some intoxicant is not supposed to be a person of sound mind. Qualification, in point 3, requires that a person entering into a contract should not be disqualified by his status in entering into such contracts. Such persons are an alien, enemy, foreign sovereigns, convicts, etc. they are disqualified unless they fulfill certain formalities required by law. Contracts entered by persons not competent to contract are not valid. Next is lawful consideration and object. The consideration and object of the agreement must be lawful. Section states that consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provisions of law, if it is fraudulent or involves injury to the person or property of another, or court regards it as immoral or opposed to public policy. Example: A promises to drop prosecution instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is void, as its object is unlawful. Example: A agrees to sell his house to B against 100 kgs of drugs. Such agreement is illegal as the consideration is unlawful. Next is not expressly declared to be void. The agreement entered into must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. A void agreement is one without any legal effects. Example: threat to commit murder, or making/publishing defamatory statements, or entering into agreements which are opposed to public policy are illegal in nature. Similarly, any agreement in restraint of trade, marriage, legal proceedings, etc. are classic examples of void agreements.
Section 29 Agreement void for uncertainty. An agreement is void if the meaning of such agreement is not certain, or not capable of being made certain. Some examples for better understanding. A agrees to sell B some tons of oil. The agreement is void for uncertainty since the description of oil is not specified. Second, A agrees to sell B 100 tons of oil of a specified description, known as an article of commerce. There is no uncertainty and therefore the agreement is not void. Third, Mr. A, who is a dealer in coconut oil only, agrees to sell to B 100 tons of oil. The nature of A's trade implies that intends to sell 100 tons of coconut oil. So, there is no uncertainty. Fourth, A agrees to sell to B all the grain in his granary at Lakshmi Nagar. There is no uncertainty since it is possible to determine the quantity of grain lying at B's granary at Lakshmi Nagar. Fifth, A agrees to sell to B 1000 kgs of rice at a price to be fixed by C. As the price is capable of being made certain, there is no uncertainty to make the agreement void. Last example. A agrees to sell to B his white horse for Rs 500 or Rs 1000. There is nothing to show which of the two prices was to be given. Therefore, the agreement is void. Next topic. Section 56 Agreement to do impossible act. Agreement to do impossible act. If an agreement is made to do a particular act, at the time of making of agreement, it is certain that such an act is impossible, then the agreement is void. Agreement to do an act which subsequently becomes impossible. If a contract is made to do a particular act, at the time of making of contract, such an act is not impossible. After the contract is made, such an act becomes impossible. Then the contract has become void. Next topic we going to learn about offer or proposal and acceptance. Promise. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Next is promisor and promisee. When a proposal is accepted, the person making the proposal is called as promisor, and the person accepting the proposal is called as promisee.
Next topic is types of contract. Refer the chart on the screen. I will explain every single topic here. Let's move on to the very first topic: type of contract: validity and enforceability. On the basis of the validity. First is valid contract. An agreement which is binding and enforceable is a valid contract. It contains all the essential elements of a valid contract. Example: A asks B if he wants to buy his bike for 10,000 rupees. B agrees to buy bike. It is agreement, which is enforceable by law. Hence, it is a valid contract. Second, void contract. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. A void contract is one which cannot be enforced by a court of law. Example: Mr. X agrees to write a book with a publisher. Such contract is valid. However, after few days, X dies in an accident. Here the contract becomes void due to the impossibility of performance of the contract. Thus, a valid contract when cannot be performed because of some uncalled happening becomes void. Example: A contracts with B, owner of the factory, for the supply of 10 tons of sugar, but before the supply is effected, the fire caught in the factory and everything was destroyed. Here the contract becomes void. It may be added by way of clarification here that when a contract is void, it is not a contract at all, but for identifying it, it has to be called a void contract. Third, voidable contract. Section 2(I) defines that an agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of the other or others, is a voidable contract. This in fact means where one of the parties to the agreement is in a position or is legally entitled or authorized to avoid performing his part, then the agreement is treated and becomes voidable. Such a right might arise from the fact that the contract may have been brought about by one of the parties by coercion, undue influence, fraud, or misrepresentation, and hence the other party has a right to treat it as a voidable contract. Example: X promised to sell his scooter to Y for 1 lakh. However, the consent of X has been procured by Y at a gunpoint. X is an aggrieved party and the contract is voidable at his option but not on the option of Y. It means if X accepts the contract becomes a valid contract, then Y has no option of rescinding the contract. Fourth, illegal contract. It is a contract which the law forbids to be made. The court will not enforce such a contract but also the connected contracts. All illegal agreements are void, but all void agreements are not necessarily illegal. Despite this, there is similarity between them, is that in both cases they are void ab initio and cannot be enforced by law. Example: contract that is immoral or opposed to public policy are illegal in nature. Similarly, if R agrees with S to purchase brown sugar, it is an illegal agreement. According to Section 2(g) of the Indian Contract Act, an agreement not enforceable by law is void. The Act has specified various factors due to which an agreement may be considered as void agreement. One of these factors is unlawfulness of object and consideration of the contract, that is, illegality of the contract which makes it void. Fifth, unenforceable contract. Where a contract is good in substance but because of some technical defect, i.e., absence in writing, barred by limitation, etc., one or both the parties cannot sue upon it, it is described as an unenforceable contract. Example: A bought goods from B in 2015. But no payment was made till 2019. B cannot sue A for the payment in 2019 as it has crossed 3 years and barred by Limitation Act. A good debt becomes unenforceable after the period of 3 years as barred by Limitation Act. Next we are moving on to on the basis of the formation of contract. First, express contracts. A contract would be an express contract if the terms are expressed by words or in writing. Section 9 of the Act provides that if a proposal or acceptance of any promise is made in words, the promise is said to be express. Example: A tells B on telephone that he offers to sell his house for 2 lakhs and B in reply informs A that he accepts the offer. This is an express contract. Second, implied contracts. Implied contracts in contrast come into existence by implication. Most often the implication is by action or conduct of parties or course of dealings between them. Section 9 of the Act contemplates such implied contracts when it lays down that in so far as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. Example: where a coolie in uniform picks up the luggage of A to be carried out of the railway station without being asked by A and A allows him to do so, it is an implied contract and A must pay for the services of the coolie detailed by him. Another example: A drinks a coffee in restaurant. There is an implied contract that he should pay for the price of coffee. Third, quasi-contract. A quasi-contract is not an actual contract but it resembles a contract. It is created by law under certain circumstances. The law creates and enforces legal rights and obligations when no real contract exists. Such obligations are known as quasi-contracts. In other words, it is a contract in which there is no intention on part of either party to make a contract but law imposes a contract upon the parties. Example: obligation of finder of lost goods to return them to the true owner, or liability of person to whom money is paid under mistake to repay it back cannot be said to arise out of a contract even in its remotest sense, as there is neither offer and acceptance nor consent. These are said to be quasi-contracts. E-contracts. When a contract is entered into by 2 or more parties using electronics means, such as emails, is known as e-commerce contracts. In electronic commerce, different parties/persons create networks which are linked to other networks through EDI, that is, electronic data interchange. This helps in doing business transactions using electronic mode. These are known as EDI contracts or cyber contracts or mouse-click contracts. Next we are moving on to last one. On the basis of the performance of the contract. First, executed contract. The consideration in a given contract could be an act or forbearance. When the act is done or executed or the forbearance is brought on record, then the contract is an executed contract. Example: when a grocer sells a sugar on cash payment, it is an executed contract because both the parties have done what they were to do under the contract. Second, executory contract. In an executory contract, the consideration is reciprocal promise or obligation. Such consideration is to be performed in future only, and therefore these contracts are described as executory contracts. Example: where G agrees to take the tuition of H, a pre-engineering student, from the next month, and H in consideration promises to pay G Rs 0.1,000 per month, the contract is executory because it is yet to be carried out. Unilateral or bilateral are kinds of executory contracts and are not separate kinds. Unilateral contract. Unilateral contract is a one-sided contract in which one party has performed his duty or obligation and the other party's obligation is outstanding. Example: M advertises payment of award of Rs 5,000 to anyone who finds his missing boy and brings him. As soon as B traces the boy, there comes into existence an executed contract because B has performed his share of obligation and it remains for M to pay the amount of reward to B. This type of executory contract is also called unilateral contract. Bilateral contract. A bilateral contract is one where the obligation or promise is outstanding on the part of both the parties. Example: A promises to sell his plot to B for Rs.1 lakh cash down, but B pays only Rs.25,000 as earnest money and promises to pay the balance on next Sunday. On the other hand, A gives the possession of plot to B and promises to execute a sale.